A warm welcome to all. The Honorable Acting Chief Justice of Bombay High Court, Shri Ravindra GHUGE sir, Honorable Shri AJEY S. GADKARI sir, Learned Additional Solicitor General Shri Anil Singh, Learned Advocate General Shri Milind Sathe, Honorable Judges and former judges of the Bombay High Court, Learned Senior Advocate, distinguished members of the bar, esteemed guests, participants, a very good morning to all of you. On behalf of Advocates Association of Western India, I extend a warm welcome to each of you at the 2-day intensive workshop on arbitration and mediation. The association is deeply privileged and grateful to my Lord the Acting Chief Justice Shri Ravindra GHUGE sir and my Lord Justice AJEY S. GADKARI sir for gracing today's inaugural ceremony with their esteemed presence. To mark the auspicious commencement of this workshop, I request our dignitaries on the dais to kindly step forward and light the ceremonial lamp. Now you go.
असतो मा सद्गमय तमसो मा ज्योतिर्गमय मृत्योर्मामृतं गमय ॐ शान्ति शान्ति शान्तिः. This mantra.
असतो मा सद्गमय तमसो मा ज्योतिर्गमय मृत्योर्मामृतं गमय ॐ शान्ति शान्ति शान्तिः. असतो मा सद्गमय तमसो मा ज्योतिर्गमय मृत्योर्मामृतं गमय ॐ शान्ति शान्ति शान्तिः.
From the darkness of ignorance, lead us to the light of knowledge and wisdom. Thank you very much for the honorable dignitaries during the 2-day session. Thank you very much, sir. We shall now proceed to welcome and felicitate our distinguished guests. We are honored to have presiding over today's function Honorable the Acting Chief Justice Shri Ravindra GHUGE sir, a stalwart of law, a judge known for his analytical sharpness, discerning judicial mind, and steadfast commitment to substantive justice. My Lord, the association feels truly blessed by your gracious presence. May I now request our President Shri Prashant Redekar and Secretary Shri Suresh Sabrat to welcome my Lord Acting Chief Justice Shri Ravindra GHUGE with a floral bouquet and a memento. Justice Shri AJEY S. GADKARI, renowned for his high intellect, strict courtroom discipline, and decisive adjudication of matters. My Lord, the association remains deeply indebted to you for honoring us with your presence. I request our treasurer Shri Rakesh Bhatkar and Dr. Dhruti Kapadia to welcome my Lord Justice AJEY S. Gadkari with a floral bouquet and memento. Thank you, sir. Joining us on the dais is an accomplished veteran of the Bombay High Court and an authority on arbitration law, learned Additional Solicitor General Shri Anil Singh, sir. I request our Joint Secretary Shri Vikram Walawalkar to welcome Shri Anil Singh, sir, with a floral bouquet. May I request Mr. Gorwadkar to please felicitate the Additional Solicitor General Shri Anil Singh, sir, with a floral bouquet and a memento. We are also privileged to welcome a constitutional scholar, a formidable advocate, and an institution of law in himself, learned Advocate General Shri Milind Sathe, sir. I request our association Vice President, Mrs. Prachi Tatke, Madam, and Shri Sukumar Ghanwat to welcome Shri Milind Sathe, sir, with a floral bouquet and a memento. For today's function, we have got a dignitary who is a chairman of Arbitration and Mediation Committee of Indian Merchant Chambers, Shri Gautam Mehta. I must candidly admit that the course conducted by IMC and his leadership is our inspiration, and therefore the association feels privileged to felicitate him on today's occasion. May I now request our Mr. Walawalkar to felicitate Mr. Gautam Mehta with memento and floral bouquet. Thank you very much, dignitaries. May I request the dignitaries to have a seat, my lord. The Advocates Association of Western India, having recently completed 162 glorious years of service, has consistently contributed to nation building and strengthening of our judiciary. Today, practice in arbitration and mediation is no longer an optional skill. It is an absolute necessity. The judiciary has recognized alternative dispute resolution not as a cosmetic add-on, but as a system-level imperative. As advocates, our responsibility is to support this ecosystem by identifying settlement-worthy disputes, offering realistic counsels, and also actively driving effective arbitration and mediation processes. To build this capacity within our bar, this intensive workshop was conceptualized. The vision behind this initiative comes from our President, Shri Prashant Relekar. May I now invite President Shri Prashant Relekar sir to address the gathering.
Good morning, everyone. Good morning, Honorable Chief Justice of Bombay High Court, Sri Ravindra GHUGE, today's Chief Guest, Honorable Justice AJEY GADKARI, Honorable Judges of the Bombay High Court, learned senior advocates, distinguished members of the bar, learned speakers, ladies and gentlemen. It is my proud privilege to welcome you all to this capacity building workshop on arbitration and mediation. AAWI has always done its best for the lawyers community. We have taken several efforts to support our legal community, particularly young lawyers, right from distributing AI tools, which we have distributed recently on subsidy, and then distributing iPads on subsidy. We have also seen to it that our lawyers community gets equipped and walk with time. Today, we are extremely happy to hold this historic workshop on arbitration and mediation, a subject which is considered as the future of law. Today's workshop is another step in that direction. We are especially honored to have with us today our Acting Chief Justice, Sri Ravindra GHUGE, Chief Guest of Honor, Justice AJEY GADKARI. Thank you, Your Lordship, for taking time out of your demanding schedule to guide us today. Your participation set a brilliant benchmark and adds immense value for what we hope to achieve over the next 2 days. I also want to extend a special warm welcome to all the speakers and High Court judges who will be leading our technical session. We are deeply grateful for the mentorship, your effort to teach our lawyers and enhance the skill would be remembered for the years to come. Looking around this room, we have incredible mix of seasoned lawyers and sharp young minds. We are all here for one singular reason, capacity building. Today, a client definition of winning just a judgment after 10 years. Winning means get a fast, fair and final resolution. That is where arbitration mediation comes in. ADR, alternative dispute resolution, is no longer just a backup option. It is a frontline of a modern legal practice. Over the next 2 days and across 7 intensive sessions, we are going to dive deep into its mechanism. We are not just learning the law, we are building our muscles as future-ready lawyers. We have 2 days. We have 7 sessions. Mostly importantly, we have best legal minds from the High Court bench and senior advocates right here to guide us. Court will always remain the guidance of justice, but the mature legal system is not measured merely by the number of judgments it is delivered. It is equally measured by the ability to resolve dispute fairly, efficiently, and with the confidence of those who seek justice. Arbitration and mediations are not just intent to replace the court. They are intent to support the larger justice delivery system for which the court remains the cornerstone. My only request to everyone in this room to make this interactive, do not just sit back and take notes, because we have given a very good diary to you, all of you. Ask the tough questions, challenge the scenario, use the question and answer session to clear your doubts straight from the source. Talk to each other during the break, network, share your courtroom experience and learn from another. Take the opportunity to connect the fellow professionals and build a lasting professional relationship. Before I conclude, I would like to acknowledge 2 individuals whose dedication has been instrumental in making this workshop reality. Advocate Tejas Dande. has been a driving force behind the planning, coordination and execution of this program. He has worked tirelessly often behind the scene, ensuring that every aspect of this workshop was organized with precision and care. Equally, I would like to express our sincere appreciation to Advocate Pinky Bansali, who has served as the lead researcher and for this workshop. The academic strength for this program is a reflection of her meticulous research, thoughtful preparation, and firm commitment. Together, they have devoted countless hours to planning, coordinating, and executing the initiative and the success of this workshop. In a small measure, a testament to their hard work. On behalf of Advocate Association of Western India, I thank them both of their outstanding contribution. Once again, thank you, Justice GHUGE, Justice GADKARI sir, and all the distinguished judges for being here. Thank you to each of you for investing the 2 days in your professional growth. Let's make this 2 days count. I formally declare this capacity building workshop of arbitration and mediation is open. Thank you and have a wonderful, productive learning experience. Thank you.
Thank you, President Redekar sir, for setting the stage for this workshop. Getting blessings and good wishes from those who is really experienced, cooperative and helpful to us. May I now request Shri Gautam Mehta sir, the Chairman of Arbitration and Mediation Committee of Indian Merchant Chambers, to give wishes for this 2-day workshop in 2 minutes. Thank you, sir. Please.
Thank you, Tejas. Respected Acting Chief Justice, Bombay High Court, Justice Gadkari, other judges of Bombay High Court, many of whom have been a part of IMC in the training program, including the Additional Solicitor General and the Advocate General. And I see the President of BBA, Mr. Nitin Thakkar here, President of Bombay Law Incorporated Society, Mr. Nilesh Modi. They've all been connected. To our mind, today's seminar is very, very important. And for the past 20 years, we at IMC, that is the IMC's Arbitration Committee, has been driving towards it by holding a 7-day annual course. I told Tejas when we spoke, I said that the Arbitration Committee will support any initiative by anybody for arbitration in Mumbai. Reason being that today arbitration is not merely an extension of court. Commercial matters are increasing as commerce business increases. It's not enough to have Mumbai as the center. This has to spread all over our state. It becomes important for young lawyers to become a part of it, to get trained, to understand, to think from a commercial angle. So for that purpose, on behalf of IMC's Arbitration Committee, we extend a full support to this, and we hope that this initiative continues, and whatever way we can help, we will help. So my co-chairman is here. So supposing I have to demit office as the chairman, I know he will continue, and we want this legacy to continue. And I went through the whole today's topics and speakers. Very well selected, very eminent people speaking. I would request all participants, please make the best of it. Don't treat it as a Saturday, Sunday small seminar. It's a very important thing. Wish you all the best, and thank you very much.
Thank you, Mehta sir. Recognizing the urgency and importance of this subject, AAWI has structured this 2-day course to cover statutory frameworks alongside practical trial strategies. Over the next 2 days, our members will be guided by 7 honorable judges of the Bombay High Court, 7 senior advocates, a district judge and master trainer from the Supreme Court Mediation and Conciliation Project Committee, and a senior accredited mediator. Reflecting the immense demand for this training, all 600 plus seats were fully registered within just a few hours of opening the registrations. The House is eager to hear from our distinguished bench. May I now humbly request our guest of honor, Honorable Justice Shri AJEY S. GADKARI sir, to kindly address the gathering.
A very good morning to all. Honorable the Acting Chief Justice, Sri Ravindra GHUGE, my esteemed colleagues who are present here, Mr. Anil Singh, Learned Additional Solicitor General of India, Dr. Milind Sathe, Learned Advocate General of Maharashtra, Mr. Gautam Mehta, expert in arbitration, and the President of Arbitration of Indian Merchant Chambers, Advocate Mr. Prashant Redekar, Chairman of Advocates Association of Western India, alias AAWI, Senior Advocate Mr. Nitin Thakkar, President of Bombay Bar Association, Advocate Mr. Suresh Sabrat, Secretary AAWI, respected senior advocates, honorable members of the Managing Committee of AAWI, all the learned advocates present here for attending this workshop, ladies and gentlemen. This workshop on arbitration and mediation is being conducted by AAWI on the topics of arbitration and mediation. Dr. Babasaheb Ambedkar has said that rights are protected not only by mere laws, but by the prompt and effective administration of justice. The Indian justice delivery system has historically faced challenges such as prolonged delays, increasing pendency of cases, and high litigation costs, which have encouraged the development and promotion of alternate dispute resolution, that is ADR mechanism. The Supreme Court of India has repeatedly emphasized the importance of ADR as an effective method for reducing the burden on courts and providing speedy and efficient dispute resolution. The speedy justice system is one of the fundamental requirements of any society. Keeping that in mind, when the courts were overburdened with cases and the average time required for deciding a lease increased substantially, the steps were taken to decrease the burden of courts. Various specialized tribunals, commissions are established under the law. Similarly, alternate dispute resolution, for short ADR, came up as a future of traditional dispute resolution system. Arbitration is the most integral part of ADR. Section 89 in its present form is inserted by repealing the earlier section and has come into effect from 2002. It states that where it appears to the court that there exist elements of a settlement which may be acceptable to the parties, the court shall formulate the terms of settlement and give them to the parties their observations, and after formulating or reformulating the terms of a possible settlement, refer the same for arbitration, conciliation, judicial settlement including settlement through Lok Adalat or mediation. ADR mechanisms including arbitration, mediation and conciliation provide parties with alternatives to traditional court litigation by enabling disputes to be resolved through flexible, consensual and specialized procedures. Arbitration is a process in which disputes are submitted to an arbitrator whose decision is generally binding upon the parties. Conciliation and mediation are processes in which a neutral third party assists disputing parties in reaching a mutually acceptable settlement. ADR mechanisms is an alternative to the formal legal system of courts. The system of ADR has been established because of the need of the people to change the way in which dispute traditionally resolved. The burden of the courts is to a large extent reduced by resorting to the ADR mechanisms. The legal cost is also comparatively less in ADR mechanisms. The ADR method is effectively utilized by many people as dispute resolution by court is formal in nature and a common man may get intimidated by the same. Alternative dispute resolution effectively means resolution of dispute out of courts, which is alternative to the normal means of mode of settlement of disputes. In India, arbitration has developed as an important mechanism for resolving commercial and international disputes due to the legal recognition provided under the Arbitration and Conciliation Act 96, which was enacted to consolidate and amend the law relating to domestic arbitration, international commercial arbitration, and enforcement of foreign arbitral awards. The Act is based on principles of parity, principles of party autonomy, minimal judicial intervention, and speedy dispute resolution. Despite significant progress, ADR mechanisms in India continue to face challenges, including limited public awareness, shortage of trained mediators and arbitrators, lack of uniform institutional practices, and concerns regarding enforcement and procedural efficiency. Strengthening legal infrastructure, improving professional training, and increasing awareness among stakeholders remain essential for achieving the full potential of ADR in India. It is said that the appellate side bar generally comes across or deals with cases arising out of Maharashtra Land Revenue Code, Tenancy and Agricultural Lands Act, Cooperative Societies Act, Project Affected Persons Rehabilitation Act, Fair Compensation and Transparency in Land Acquisition Act, Labor and Industrial Laws, and other related central and local laws. It is said that generally the litigation on the appellate side is conservative and traditional in nature. The future of litigation through arbitration and mediation in India lies in developing a balanced relationship between traditional court proceedings and alternative dispute resolution mechanisms. The integration of ADR into Indian legal system has the potential to provide faster, economical, and effective access to justice while supporting the constitutional objective of ensuring justice for all. The scope of litigation under Arbitration and Conciliation Act and the Mediation Act 23 is expected to focus on faster, more efficient, and less expensive dispute resolution through alternative dispute resolution mechanisms. With increasing judicial support and legislative reforms, arbitration and mediation are likely to become the preferred methods for resolving commercial, civil, and contractual disputes. The growth of institutional arbitration, greater use of pre-litigation mediation, and the expansion of online dispute resolution through digital platforms will further improve access to justice and speed up the resolution process. At the same time, courts will continue to play an important supervisory role by appointing arbitrators, granting interim relief, enforcing arbitral awards, and mediated settlements, agreements, and ensuring fairness in ADR proceedings. As India continues to strengthen its ADR framework and align it with international standards, the role of litigation is expected to shift from being the primary means to dispute resolution to supporting and facilitating effective ADR processes, thereby creating a more efficient, accessible, and business-friendly justice system. The future scope of arbitration and mediation in India is expected to expand due to increasing commercial activities, globalization, technological development, and the need for efficient dispute resolution mechanisms. The growth of institutional arbitration centers, online dispute resolution platforms, and professional mediation services indicates a movement towards a more structured and accessible ADR framework. In view of the globalization, new companies and various other stakeholders have entered and are entering into commercial market, and the need to have expeditious dispute resolution procedure, adopting the arbitral procedure appears to be the need of the time, and therefore it is necessary for the advocates to get themselves adapted to the new avenues of law. This workshop is so designed to not only get a broad but in-depth knowledge and information about the Arbitration and Mediation Acts, inter alia, the arbitration and mediation proceedings. Chairpersons of each sessions are the honorable judges of our court, and the speakers are learned senior advocates having vast experience in the field of law. The workshop has been designed in such a way that during the sessions scheduled hereinafter, the speakers will not only express their views, but also enlighten the participants on their respective topics, which have been more specifically mentioned in the invitation and or the brochure published by the AAWI. I sincerely request all the advocates to wholeheartedly participate in the workshop and derive maximum possible information and knowledge and benefit from it. Thank you. Jai Hind.
Thank you, my lord, for those sharp and illuminating remarks. I now have the distinct honor of requesting our chief guest, Honorable, the Acting Chief Justice of Bombay High Court, Shri Ravindra Vittalrao GHUGE sir, to deliver the inaugural keynote address.
My esteemed sister and brother judges of the Bombay High Court, Justice A.S. GADKARI, Senior Administrative Judge, speakers in the various sessions, Justice G.S. Kulkarni, Junior Administrative Judge, Justice Suman Sham, Justice Bharti Dangre, Justice Manish Pitale, and Justice Som Shekhar, my esteemed brothers and sisters of the dais, the learned Additional Solicitor General of India, Mr. Singh, the learned Advocate General of the State of Maharashtra, SHRI Sathe, Dr. Sathe, the Dynamic Advocates Association of Western India, AAWI, and esteemed members of the bar, senior advocates, a very good morning to you all. It is my distinct privilege and profound professional pleasure to stand before you today to inaugurate this meticulously organized 2 days workshop. We are gathered here with a unified critical objective: capacity building, expanding our jurisprudential horizons, and fundamentally enhancing the appellate bar's participation in the essential fields of arbitration and mediation. Tomorrow we will have the distinct honor of the Honorable the Chief Justice of India, Shri Justice Surya Kant, for the valedictory program through the online mode. We are trying our best to ensure that if he is in station, so then he could address us, and I believe the probability is very high, the possibility is equally high. His Lordship's address and lecture on mediation will undoubtedly serve as a fitting crescendo to what promises to be an intellectually rigorous and transformative 2 days of deliberations. We gather here in Mumbai, the financial capital of our nation, not merely to dissect statutory provisions, but to reflect deeply on the very evolution of the dispute resolution. Traditional litigation, while being the undeniable and proud cornerstone of our justice system, cannot single-handedly bear the staggering weight of India's burgeoning commercial, corporate, and civil disputes. The dockets are heavy, the stakes are unprecedented, and the demands of a modern globalized economy are incredibly fast-paced. We often use the term alternate dispute resolution, but I put it to this august gathering today. When a method provides faster, more specialized, and more amicable justice, it is no longer an alternative. It has purposefully emerged as the primary indispensable avenue for commercial justice. Consider for a moment the construction and infrastructure sectors, which are the very lifeblood of our nation's development and economic ascendancy. Disputes in these arenas do not merely affect the balance sheets of private corporations. They have a cascading effect that can paralyze public progress, deter foreign investment, and stall national growth. A few years ago, a high-stakes infrastructure project involving a major joint venture was completely stalled due to rapidly escalating costs and intractable technical deadlocks. Had that dispute entered the typical trial system, navigating through multiple tiers of civil appeals, it would have probably languished for a considerable time. The machinery would have rusted and the public would have been deprived of a vital asset. Instead, it was referred to the institutional arbitration. Within a matter of months, an expert tribunal navigated the highly technical complexities and delivered a binding award that allowed the project to resume and reach fruition. This saved millions in public funds, preserved thousands of livelihoods, and averted a systematic breakdown. This is not just a singular success story. It is a vital blueprint for the future of commercial dispute resolution in India. Furthermore, as cross-border trades expand and our commercial footprints grow, we are constantly navigating the intricate complexities of international commercial arbitration. We routinely deal with high nuanced issues like anti-suit injunction, the enforcement of foreign awards, and complex jurisdictional overlaps. In all these spheres, our domestic and international overarching goals remain the same: swift, binding, and effective resolution that commands the respect of the global business community. This brings me to the core philosophy of what we are collectively trying to achieve over these 2 days. Over a century and a half, Abraham Lincoln offered a profound, timeless advice to the legal profession. It stood the test of time for all these centuries. He said, and I quote, "Discourage litigation. Persuade your neighbors to compromise whenever you can. Point out to them how the nominal winner is often a real loser in fees, expenses, and waste of time. As a peacemaker, the lawyer has a superior opportunity of being a good man." Unquote. These words resonate with compelling urgency today. Arbitration and ADR mechanisms at large are not merely administrative pressure release valves for an overburdened judiciary. They are inherently superior avenues for specific classes of disputes. The benefits they offer are manifold, highly practical, and genuinely transformative. Firstly, ADR ensures party autonomy, empowering litigants to select subject matter experts rather than judges, to adjudicate highly specialized and technical disputes. Secondly, it guarantees confidentiality, shielding sensitive corporate information, trade secrets, and reputation from the public glare of an open courtroom. Thirdly, it offers unparalleled procedural flexibility, allowing parties to escape the rigid straitjacket of traditional procedural laws, while still rigorously maintaining the principles of natural justice. Finally, by delivering time-bound and cost-effective outcomes, ADR actively preserves vital business, time-bound and cost-effective outcomes, and personal relationship that would otherwise be irreparably destroyed in the adversarial long-drawn trial. A thriving arbitration and mediation ecosystem is therefore a fundamental prerequisite for a thriving economy. Over the next 2 days, this thoughtfully curated workshop will forensically examine our ADR framework, leaving no stone unturned. In session 1, we will critically assess the impact of the Arbitration and Conciliation Act 1996 after its robust 3-decade run. While we have made tremendous legislative and judicial strides, and legislatively stipulated arbitration is now the norm in statutory disputes involving national highways, railways, the contribution of institutional arbitration remains a steep challenge. It is a matter of particular concern when one of the biggest legislators, the state, and its instrumentalities appear hesitant to fully embrace the arbitral process, sometimes seemingly walking away from arbitration altogether. We must critically examine how the bench and the bar can foster confidence in these institutions and maximize the statute's positive impact on society. Session 2 brings us to the critical junction of sections 34 and 37, navigating the review of arbitral awards. While the law on the review of awards is quite well settled now, the jurisprudence is heavily and rigidly leaning towards preserving the absolute finality of these awards. An arbitral award cannot be treated as a mere decree of a trial court, ripe for an endless appellate journey. We must take note of the Supreme Court's 2025 landmark judgment in Gayatri Balasamy versus ISG Novasoft, which clearly and definitively delineated the boundaries of judicial interference. The court powerfully reinforced that under Section 34, the judiciary possesses only a limited power to modify an award and cannot rewrite the award or re-evaluate the case on its evidentiary merits. The bar must ask itself what it can do to build greater standards and best practices to develop wider societal acceptance of these arbitral outcomes. This necessary deference to the arbitral tribunal is further explored in Session 3, dealing with intricate interplay of Sections 8 and 16. The globally recognized doctrine of competence ensures that a tribunal rules on its own jurisdiction. This principle means that an arbitral tribunal has the power to rule on its own jurisdiction, decide if the arbitration agreement is valid, and handle challenges before courts get involved. The 7-judge bench of the Supreme Court in Re Interplay 2023 firmly embedded this by ruling that an unstamped arbitration agreement is merely a curable defect, and its validity is a matter for the arbitral tribunal to assess, not the referral court. Yet, despite clear legislative intent aimed at overcoming pre-amendment hurdles, we still see situations where courts and tribunals are presented with conflict of jurisdiction that must be carefully reconciled. However, let us be absolutely clear. A robust statute is only as good as the professionals operating within it. Section 4 touches upon a vital nerve, the lawyer's responsibilities while appearing in arbitration matters. Arbitration was specifically designed to escape hyper-technical objections, procedural insistence, and the cumbersome, protracted recording of evidence. If we import delays and endless cross-examinations, as in the civil court, into the arbitral tribunal, we may do a grave disservice to the client and actively undermine the very institution of arbitration. As the Honorable Justice Hrishikesh Roy touchingly observed, while emphasizing the need for minimal judicial intervention, courts must respect international arbitration norms and awards should only be set aside in truly exceptional circumstances. The bar must fiercely internalize this ethos of minimal interference and maximum efficiency. Following this, Session 5 will clarify the differing parameters of interim protection under Section 9, 17, and 37. It is essential that the fruits of arbitration are not lost before the final award is rendered. The efficacy of the final award is often secured at the interim stage, and understanding these precise statutory distinctions is key to securing a client's interest. Finally, on day 2, Session 6 will confront an uncomfortable truth. Mediation remains a severely underutilized means of dispute resolution. Mediation is not merely a legal process. It is profoundly psychological. It requires highly trained mediators with unique skills to break emotional and commercial impasse. There is an urgent, pressing need for an aggressive drive to train lawyers as mediators. But successful mediation also relies heavily on the environment we provide. An atmosphere of trust begins the exact moment parties walk through the door. I have always believed that physical infrastructure plays a silent but crucial role in this process. Ensuring that our facilities, like the Mediation Center at the Bombay High Court, the MSLSA office, project a dignified and professional environment, which is absolutely vital. Small details shape the mindset of the disputants, nudging them away from defensive, adversarial posturing and towards collaborative, amicable conciliation. As I conclude, I must commend the AAWI for organizing this workshop with such a structured, practical, and disciplined format. I note that each session will have opening remarks setting the context, followed by focused 10 to 12 minutes of presentation. Ensuring that speakers leave adequate time for a 15-minute question and answer session will undoubtedly trigger a highly valuable and dynamic discussion. Furthermore, the mandate for concise summaries from our speakers, circulated as workshop papers, will create a formidable repository of long-term sustainable value for all the participants. I urge the bar to utilize this session fully, engage with the speakers, challenge the existing paradigms, build your capacity, elevate your professional standards, and work with us to ensure that arbitration and mediation in India finally achieve their true transformative potential. I wish this workshop a grand success and deeply enriching deliberations. I am really sorry for the voice modulation, which has happened naturally because of a virus infection. Having tolerated me for the same, I express my gratitude to you all. God bless you all. God bless the Bombay High Court.
Thank you very much, sir. We extend our deepest gratitude to my Lord for setting a profound and guiding benchmark for this two-day workshop. To formally conclude our inaugural ceremony, I invite our Secretary, Shri Suresh Sabrar, to propose the vote of thanks.
Honorable Acting Chief Justice Shri Ravindra GHUGE, Honorable Justice AJEY GADKARI, Honorable Judges, respected dignitaries on the dais and off the dais. It gives me immense pleasure and a deep sense of privilege to propose the vote of thanks for today's inaugural function. At the outset, we are very much thankful to Honorable Chief for having accepted our invitation, presided over today's inaugural workshop and inaugurating the same. We are also thankful to the Honorable Chief for extending all cooperation for today's workshop. Thank you so much, Chief Sir. Chief Sir, we must inform your Lordships that, and all present here today, that in fact for holding today's workshop, we have received a lot of inspiration and motivation from Honorable Justice AJEY Gadkari Sir and Honorable Justice Girish Kulkarni Sir. All along, both these Honorable Justices have been motivating our association to hold workshops on arbitration and other topics. Thank you so much, sir. The association is also thankful to your Lordships to preside over the workshop along with the Honorable Chief, sir. Thank you so much, your Lordships. We are also thankful to all the Honorable Judges who are present here today to grace and bless today's workshop on this Saturday morning. Thank you so much, your Lordships. On behalf of the association, I am very much thankful to Honorable Additional Solicitor General Anil Singh, sir, and Honorable Advocate General Dr. Milind Sate, sir. Chief, sir, and Honorable Justice Gadkari, sir, I would like to inform your Lordships as well as all present here in this workshop that our association has all along been receiving all cooperation and guidance from these two stalwarts. Thank you so much, Singh sir and Dr. Sate sir, for not only extending all cooperation but also gracing today's workshop. We are also thankful to our fatherly figure, Dr. Nitin Thakkar sir, President of BBA, Nilesh Bhai, President of BLS, and the members of the Bar Council for gracing our today's workshop. We are also thankful to Gautam Mehta sir for blessing this function. We must inform and request to all the participants who are present here today that we have been blessed with very good speakers and we have all got a lot of things to learn today. Kindly pay attention and take down proper notes. Participants, please put your mobile phone on silent mode or flight mode. Best of luck to all. I thank I am very much thankful to the coordination committee for having taken pains for making all these necessary arrangements. Thank you once and all.